Hello and welcome to today's event on tech policy in the shadow of Dobbs, which is co-produced by the UCLA Institute for Technology, Law and Policy and the UCLA Law Center on Reproductive Health, Law and Policy. My name is Michael Karanicolas. I'm the Executive Director of the UCLA Institute for Technology, Law and Policy. I'll begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. The recent Supreme Court decision in Dobbs v. Jackson Women's Health Organization has sent shockwaves across the law and policy community, not only because it represents a massive rollback of reproductive rights, but also because it's potentially the most dramatic change in our legal and constitutional landscape, maybe in my lifetime, certainly in recent memory, that's going to have implications across a number of different thematic areas. Today, we're going to discuss those impacts as they relate to the law and technology space. We have an outstanding panel with us. Sapna Khatri is the Sears Clinical Law Teaching Fellow at UCLA School of Law and the Williams Institute. Ava Galperin is the Director of Cybersecurity at the Electronic Frontier Foundation. And Kendra is the Director for the Initiative for a Representative First Amendment at Harvard's Berkman Klein Center for Internet and Society. We are planning to set aside some time for Q&A and audience engagement at the end. So please feel free to plug your questions or comments into the chat at any point. I'd like to start with you, Sapna, for just a brief introduction of how Dobbs has changed the legal landscape around reproductive rights, as well as major regulatory developments since the decision.
Sorry, thank you so much, Michael. Great to be here and excited to talk about this, as daunting and depressing as it may be. It's grateful that we're able to gather and discuss these issues. So as many of you know, Dobbs has really changed the landscape for not just reproductive health, but a lot of other rights, and just created a lot of fear in the minds of people about what care they can access, what they can't access. But beyond that, when it comes to legally the changes that it's made, those are quite vast too. So I'm going to step back and kind of talk about what the case did on its own, what it means for upcoming litigation, and just, judicially what that means. And then from there, talk a little bit more about some of the policy shifts in just a couple quick minutes. So as many of us know, abortion has been recognized as a fundamental right that we were guaranteed by Roe versus Wade. And it was claimed under Roe versus Wade that this is a right that's protected under the liberty provision of our Constitution, under the 14th Amendment. Because it was seen as a fundamental right, that's what the Roe court decided, that meant that the states couldn't place additional or substantial obstacles in the way for people to access abortion care. This didn't mean they didn't try, but because we had the protection of Roe versus Wade, because we had this understanding that everyone has a fundamental right to abortion under the liberty provision of our Constitution, many of the states that tried to restrict or ban abortion were previously, those laws were enjoined or just not put into place for a variety of reasons. But that was the basis. That holding by under Roe versus Wade protected us and ensured that people could access abortion care. They still had hurdles. There were still barriers to that care. A lot of people couldn't afford care. There's different issues with insurance. States may have other restrictions, but those substantial obstacles, the outright banning of abortion care, was not allowed until 2 weeks ago. The Dobbs case under this Supreme Court completely shifted that framework. It rejected the holding that Roe had, that Casey had, and recognized that under their view, abortion is not a fundamental right under the Constitution. Nowhere in the Constitution do you see the word abortion. It is not clearly delineated. As such, we do not actually have this right. That on its own is a pretty monumental thing for us to see, because the Supreme Court is overturning nearly 50 years of precedent. That in and of itself is unprecedented. This court has not shied away from overturning precedent. But going back to abortion, what that means specifically for abortion care, this means that states now have the full authority to regulate abortion as they see fit. They have wide latitudes to do so. They can restrict abortion depending on when it is in the pregnancy. They can ban it completely, or they can create new protections and recognize that as a state, we want to protect abortion entirely or certain elements of it. But Under Dobbs, that understanding that we had this fundamental right to abortion has been completely eviscerated. And beyond that, the court has taken a new framework to analyze the liberty provision under the 14th Amendment. Over the last 50 years under Roe, the understanding was that we can interpret liberty as, based on a historical analysis on what people need. So that means that the rights associated with intimacy, with having a family, with privacy, autonomy, all of those were kind of analyzed through this liberty provision and recognized by the courts. But now under Dobbs, they've kind of taken away that framework and are really saying, let's go back and see what rights have been guaranteed from the time that the Constitution was written. What did we recognize at that time? And through that history and tradition, what continues to exist? So it doesn't leave much room to identify that things may change over time, technology may change over time, the surveillance landscape may change over time, our understanding of privacy and liberty may change. We're really going back to what the roots of the Constitution were. And that's why the Dobbs ruling means that cases that guaranteed protections for same-sex intimacy, same-sex marriage, contraception are also extremely vulnerable because of the Dobbs ruling that took away abortion. We can talk more about that later. I want to be cognizant of time. So all I'll say in terms of the policy landscape, states have not been shy to take advantage of the fact that the ball is now fully in their court. So a number of states that had trigger bans have triggered their bans on abortion care. I think there's about 23 to 26 states that have some type of trigger ban on the books, many of whom have already been implemented. There are a couple that are being challenged, but for the most part, these trigger bans have done their job. They have incited fear in people that I live in a state where they are not abortion friendly. They don't protect my right. So now I can't get the care that I need. There are a couple states that are passing protections, California being one of them. But on the whole, we're seeing a lot more discussion in state legislatures on what restrictions can be passed. Abortion protective states are doing more creative thinking on what they can do beyond just protecting abortion within their borders, but also increasing access to care, increasing the workforce. So I think we're going to see some additional developments there. And just this morning, we saw the executive order from President Biden, where he's finally chiming in and trying to say that we will, as a country, safeguard access to reproductive health care. The nuances there are still being analyzed, but overall, I think that's just a very basic first step. There's still a lot more that needs to be done. And I think our conversation today will kind of shed light on that, but I'll pause there because I think that gives you a basic kind of background on Dobbs.
Yeah, thanks very much for that. And certainly we understand this is a very fast moving regulatory and policy landscape. So I very much appreciate that grounding. We'll turn now to the implications of this decision from a more tech perspective, maybe starting with Ava, who I think framed it really poignantly in the immediate aftermath of the decision that we're not going back to a pre-Roe state of affairs, because at the time when Roe was first handed down, there was not the massive surveillance apparatus that exists today. So maybe we could hear from you an introduction to the privacy and surveillance implications of this decision and what that means from that perspective.
Sure. Hey there, I'm Eva. I'm the Director of Cybersecurity at the Electronic Frontier Foundation. And there's good news and there's bad news when it comes to the intersection of technology and the Dobbs decision. I will start with the bad news because it's very spooky. The bad news is that this is not 1973, and we are living in an unprecedented era of digital surveillance. There is so much more information available about what a person does every day, about where a person is going, what a person is thinking, and their communications with both their healthcare providers and their loved ones. We carry tracking devices around in our pockets. We have an entire industry of adware and physical tracking that is commercially available to anybody who wants to get the information. You don't even have to show up with a subpoena or a warrant. Furthermore, extremely revealing information, such as your location, because people who need abortions may cross state lines in order to go to abortion clinics. will still be very weakly protected by the law. I took a very quick look at the Biden executive order, and it talks about health information protected by HIPAA. You know it's not protected by HIPAA, whether or not you've walked into a Planned Parenthood. And often this information is available for purchase by anybody. Sometimes it is quote unquote anonymized, but this information is incredibly easy to de-anonymize. If you have location information for people over time, you can draw some very powerful conclusions about who they are. And that is because over time, the place where you sleep is probably your home. The place where you go from 9 to 5 during the week is probably your place of work. And so the idea that these things are in any way meaningfully anonymized is in my opinion, laughable. So we have this entire sort of network of digital surveillance and extremely weak protections right now. And this is extremely worrisome. People in tech have spent some time thinking about this problem, and they are, running around giving advice about how to do operational security for people who are providing abortion services, where you usually recommend that people compartmentalize this part of their life very thoroughly from the rest of their lives. And people who provide abortion support have known this for quite some time. They have been targeted with threats, with picketing, with murders. There has essentially been an entire campaign of terrorism around people who provide abortions and abortion support. So they are well aware that what you need to do is you need to protect yourself against doxing. You want to protect your identity. But also there has been a lot of advice going around for people who are seeking abortions, especially in states where abortions are illegal. And a lot of this advice is crap. There is a very fashionable bit of advice that all people who use period trackers should delete their period trackers immediately because they give away a whole lot of very sensitive health information, like, are you trying to get pregnant? Are you pregnant right now? Are you suddenly not pregnant? And on one hand, this is true. And it really caught on as advice. Even I gave this advice when it became clear that Roe was going to be overturned. But I gave this advice in the context of a huge amount of other advice. And what got amplified was everybody delete your period trackers. And what didn't get amplified was, please think about the immediate threats to people that they are facing right now. And that immediate threat does not include the subpoena of period tracking information. But it did get people thinking about companies, about how the information that companies have about us and our day-to-day lives. And it did start to get people holding the companies accountable for what they're doing with that information. So as an activist, I will take any in I can get that will start getting people to think about the surveillance landscape. But deleting your period tracker, probably not going to help. And it is a thing you can do, but it is not the most useful thing you can do right now. The flip side of that is what kind of advice should we be giving to companies and to people at this time? What we should be telling companies is you should start looking at the information that you are gathering about your users, especially your users who may become pregnant, and you should be prepared for warrants and subpoenas. And you should be protecting not just the contents of communications where people may be talking to their loved ones about their pregnancy or their pregnancy outcomes, but you should also be protecting data that is much more weakly protected under the law, such as location data, because location data can be so tremendously sensitive in this particular context. So that's what companies should be doing. What individuals should be doing is our advice should really be focused on the immediate threat to people who are currently being prosecuted for their pregnancy outcomes. And the way in which people are currently being prosecuted for their pregnancy outcomes is not that that people are being prosecuted in giant dragnets of the government looking for people who have been to the local Planned Parenthood. That is not what is happening right now. Governments are not subpoenaing your data from period tracking apps. What is happening right now is that people are being turned in by doctors, by nurses, and by the people that they trust that they have talked to about their pregnancy outcomes. And so the primary thing that individuals can do if they are talking to somebody about their pregnancy outcome, or if they are pregnant, is to be careful who they trust, to use end-to-end encrypted messengers with disappearing messages turned on, because an end-to-end encrypted message that is on somebody's device is extremely strong evidence. Whereas this person sent me a message, I no longer have it, is much weaker evidence. And finally, we recommend that people use the Tor browser for all of their browsing related to seeking out abortion services or about their pregnancy or their pregnancy outcomes. And what Tor does, for the people in the audience who are not geeks, is Tor is a browser which will disguise your IP address, and that will keep the website that you are going to from knowing your IP address. And this is extremely useful because it is easy to link your IP address to your identity. And so you want to protect your identity when you are going to, say, the Planned Parenthood website, or doing searches in Google or DuckDuckGo about your pregnancy or pregnancy outcomes. So you want to really compartmentalize that part of your life. And if this thing disguises your IP address, sounds familiar, and you're like, hey, that's what a VPN does, I have some news for you about VPNs, which is that, yes, they do this, but there is an entire sort of ecosystem of commercially available VPNs, some of which are sketchier than others, and some of which have better data privacy practices than others. And rather than spending all of your time becoming an expert in which VPN will and will not rat you out, it is easier to just download Tor browser and not think about it. When we are giving our privacy and security advice right now, we try to keep it short, we try to keep it punchy, and we try to keep it immediately actionable. Having said that, the third part of this whole issue is that we do need to think about the attacks that are coming in the future. I work for an organization with Frontier in its name, and I have spent the last 15 years traveling all over the world, mostly working with people in authoritarian countries where the law does not protect them, and where they are being targeted for their work, whether it's journalism or activism, or being a scientist that has noticed that sugar is bad for you. So there's a very wide variety of people who get targeted. And now we can add people who are seeking to end their pregnancies, or who have miscarriages, or really just anyone who is likely to become pregnant, to this list of targeted populations. And rather than counting on legal protections, the kind of advice that we give them should not only be about the kind of threats that they face now, but we should also look into the future about what threats will look like in the future. Because let me tell you, given my experience with authoritarian governments, when things get bad, they get bad really fast. And it is not possible to claw your privacy or security back in sort of in hindsight. So we do need to be prepared, and we need to start thinking about what dragnets might look like, what requests for data about everybody who has gone to this place might look like, what requests to companies for everybody who has asked to travel in order to get an abortion might look like. And so those are all questions that people who are working in tech policy need to be thinking right now, because companies move slowly. And we need to have these policies in place before these kinds of requests come in.
Thank you so much. It strikes me that a lot of the recommendations you made on the company side are things that advocacy groups have been pointing to for years around things like data minimization, although obviously, maybe there's a hope that the rise of this as a dramatic change in the threat landscape or expansion in threats that are out there will focus more attention on that. But that's an excellent summary. Kendra, I want to go to you next to discuss First Amendment and online speech questions arising from the decision. I know that's a huge topic, and there's questions around both state restrictions that are already being discussed, say around websites that counsel people living in states that are restrictive about what their options are. There's also questions about how platforms treat this kind of speech. I'm not sure if you want to capture one aspect of that or different aspects of that, but I'd be very interested to hear your thoughts. Oh, mute.
Sorry, I can't seem to unmute myself. So thank you for to the person who made that happen. Yeah, I don't know how much justice I can do to the entire environment, but I do have a couple thoughts, and I want to sort of build on something Eva was saying about sort of what's changed since 1973. And I think in some ways, I suspect Sapna and Eva already know this, but I want to flag it for folks who are listening who haven't necessarily spent as much time in the abortion space about something else that's changed since 1973. And in this, I'm drawing in particular on the sort of like my colleague Susan Yanow, who really just educated me on a lot of this. And I was like, oh, that's good to know, which is the rise of using self-managed abortion or medication as a primary means of abortion provision. That was not really an option pre-Roe, right? They're part of the reason we have things, like the Jane Collective in Chicago that were administering abortions to women who were seeking them, was because it was not like you could just take some pills and have the equivalent of a miscarriage, right? And of course, self-managed abortion pills are not an option for everyone. I'm not meaning to suggest that that's just everything that we can do, but and everyone should switch to that. But I think what I want to say to highlight, and especially as I talk about the First Amendment implications, is that it's often important to think about both self-managed abortion and going to a clinic for an abortion as both things that people are going to do and that are kind of threat modeling and are thinking about what the restrictions are going to look like need to take into account. So when we talk about what the First Amendment First Amendment implications are of restrictions on abortion post-Dobbs, a lot of this has to do with responses by pro-life or by forced birth folks to try to deal with the fact that self-managed abortion is going to be an option that I think a lot of folks have been trying to put on the table for people in places with abortion restrictions or relatively little access to clinics. So that's why I think the First Amendment stuff matters here, in part because what is useful to folks who are trying to self-manage abortion is not just access to pills, but also access to the information about how to safely take them, how to sort of manage the potential after effects, at what point you might actually need to go see a doctor, although self-managed abortion is very safe. So that's kind of the background I want to give before we dive into the First Amendment stuff, because I think it's really important to understand that it's not just about people talk about a clinic in New York advertising in Texas, and yeah, okay, sure. But that is not the fight to me personally, or that's what I don't suspect that's going to be the primary argument. I suspect that the primary argument is going to be about administering information around self-managed abortion. So, I think that basically what we've seen in the kind of online speech First Amendment space is a couple of things. One is, and I think it's really important to talk about, to Eva's point, why this is not just some imaginary problem, right? The National Right to Life Committee, one of the primary forced birth advocacy organizations, has released a draft bill where they basically suggest criminalizing aiding and abetting an abortion. And in that definition of criminalizing aiding and abetting an abortion, they include the counseling somebody over the phone about, or providing information online about what is effectively probably self-managed abortion, or I guess access to a clinic. But I think frankly, it's about self-managed abortion. So that's the context in which we're kind of talking about First Amendment restrictions and First Amendment challenges, and platform stuff is very real, at least model legislation that has been introduced or that has been sort of circulated that shows that this is something that folks are thinking about as a vehicle for restricting people's access to abortion information. And then the question is like, yeah, but is that constitutional? And like, see the answer that I'm not sure about, I know much about that answer to that question ever anymore after, after Dobbs. But, there is both reasons to feel positive about the ability to circulate abortion information and First Amendment defenses to it, even if there were state laws that were passed to restrict it. And there's reasons to be a little nervous. So, in some ways, same answer as Eva, which is there's good stuff and there's bad stuff. The primary thing I want to emphasize is that, the United States does have robust free speech protections, and they often, sweep far further than they do in other jurisdictions. And that effectively means that, to the extent that states are passing laws that really restrict speech, those are going to be robust areas for challenge. First Amendment is going to be a robust areas for challenge. However, there's this thing called the speech integral to criminal conduct exception to the First Amendment. And this is just basically the idea that governments can regulate speech that would otherwise be First Amendment protected under this exception that allows for them to regulate speech that's integral to a criminal act. And so the context in which this often comes up is something like solicitation, or prostitution. But basically just this idea where, if their speech is integral to the criminal act, governments can in fact regulate it. And that's what worries me about thinking about these laws post Dobbs is, abortion, if abortion is criminalized in a particular state, then, you are looking at the application of the speech integral to criminal conduct exception as you think about how litigation might go about these various laws. One thing to note here is that generally speaking, when you look at this case law, like other areas of First Amendment in the First Amendment space, courts tend to try to draw a distinction between aiding and abetting or supporting a specific criminal act versus a general statement. So what that looks like in practice is saying I will aid and abet abortion on Twitter, it's probably going to be much easier to maintain a First Amendment protection for that than the provision of specific information about a self-managed abortion to a person who then goes through with a self-managed abortion, right? And part of the reason I know that this is because of the litigation that EFF has been one of the primary counsels on in Woodhull versus Freedom Foundation versus the United States, which is the litigation that resulted from the passage of FOSTA, which is a bill that targeted online people who are doing sex work who were advertising online. And basically, if you read the litigation history on that, part of what has made that bill feel constitutional, or what that law be constitutional, is at least, or the courts think that the law is constitutional. EFF is currently appealing. The fact that it refers to specific instances of prostitution as opposed to general statements about prostitution, and that's how courts kind of try to reconcile what is effectively the criminalization of speech with a constitutional order that's super speech protective. So without getting too much further into that, because I have already gone deep down the rabbit hole, I want to offer two more very quick thoughts. One, with regards to the intermediary liability thing, again, some good news, some bad news. The good news is that state online platforms generally cannot be held liable under state criminal law for the speech of their users. That's Section 230. So, what that means is that it will be difficult to sue Facebook for users in disseminating abortion information on the platform. You can still sue the users, you just can't sue Facebook. The reason that's good news is because it removes one of the levers by which states might try to hold platforms accountable for the dissemination of abortion information. The bad news is, well, A, that you could still sue the users, but B, that that doesn't mean that online platforms may not still choose to restrict abortion information about abortion, either due to an abundance of caution or whether they think that that's the appropriate thing to do. And we've already seen some back and forth where there is some indication that information around abortion or self-managed abortion might be getting taken down faster than other types of information about sort of pills or drugs or guns. All of which is a little weird that we're putting these all in comparable categories. But the good news is that Section 230 does provide robust protections against state criminal law. It would not help against federal criminal law. So, if we have federal criminal law that bans the dissemination of abortion information and it's found to be constitutional, that's not going to help with Section 230 will not help you. The last thing I want to note is that the last reason to be a little nervous is that I have a former student who once called it the abortion exception to the First Amendment, and I've always found that a particularly evocative phrase, which is to say that generally courts have actually sort of done some weird things in the First Amendment space when it comes to abortion. And the primary example I'd cite here is Rust v. Sullivan, right, which is a case involving whether the federal government can basically put a gag on doctors from talking about abortion if they take federal funds. And then the thing to note there is that one might consider that a pretty open and shut First Amendment case about being coerced speech. Again, it's not like these doctors were asking the federal government to pay for the abortion speech. They were just saying, I don't want to be gagged from talking about abortion as a family planning option if I'm taking federal funds. The Supreme Court found that that was constitutional. It was an appropriate condition on federal funds. And my personal view is it's hard to reconcile Rust with the rest of the First Amendment doctrine if you don't think that something funky is going on when we're talking about abortion. So that I think generally does make me a little concerned about what we're going to see in terms of First Amendment challenges and whether those challenges are going to come out a little differently than they would against other types of speech, because courts might be reluctant to give full protection to information that is trying to help folks access abortions. That was already, I think, many more than my 5 minutes. And I'm happy to talk about any of that more, but I think that's kind of how I'm thinking about the space and what I'm worried about and what's reassuring me.
Thanks. That's all really valuable stuff. I would encourage folks in the audience to enter questions that you have into the chat. We have a few in there so far. I want to start just by asking about the intersectional components to both reproductive rights and to what we've been talking about here. I think there's been some discussion about the divergent ways in which lack of abortion access impacts different communities in terms of the impacts of other forms of discrimination on reproductive rights. I want to ask about that question more generally, but also to ask whether there are tech implications to it as well. I'm not sure who would want to take that first. Kendra was just, I don't want to throw it back to Kendra because I don't want to put too much pressure on you, but okay, sure.
I'm happy to take a first shot. And then I'm very much interested in my co-panelists' answers. So I think there's two things to think about here when we talk about sort of racial inequality and other forms of discrimination and how they impact sort of abortion access, in particular, thinking about sort of post-Dobbs and how this relates. I think one is as Eva was saying, right, we do have some good security advice for folks who are seeking abortions. Sometimes that advice can be hard to take if you are balancing 400 other things, right? So in some ways, when we talk about sort of poverty and systemic racism, right, those are factors that make it more difficult for people to do the things that they might find that might be protective, right, of them in the chance that they do face a prosecution. In addition to the fact that historically, when we look at the criminalization of negative pregnancy outcomes in the United States, the primary people who've been targets for that have been, Black and Latino women. So, you both have this question of who's going to end up getting prosecuted. And I think there's very specific racial dynamics that have historically been in play there, right? Akin to the racism that exists in the criminal system more broadly, along with sort of a more eugenic component. But then you also have the sort of reality that both time and money are resources that, are often necessary to take some kinds of security advice. The other more specific thing I want to say is that I do think that we often focus on, corporations as people who are trying to get people as holders of information. And I think that's fair because they hold a lot of information. But, one thing that the work of Kiara Bridges really emphasizes is that, government programs and, folks who are trying to get prenatal care through Medicaid, folks who are, on welfare, often are required to share vast amounts of information about their lives with the government, and that's a condition of getting aid. And so I think when we think about what it means to like talk about privacy and tech stuff and, thinking about the potential risks here, it's important to remember that it's not, as Eva has already been saying, right? It's not just about period apps. And it's also not even just about like, our communications. The last time you had a period, maybe information you were literally required to share with a doctor or a social worker, or face, a child protective services visit because, you already have a kid and you're not getting adequate prenatal care for your pregnancy. So it's really important that we think about the ways in which folks who are reliant on certain kinds of government systems don't necessarily have the option to not share information with them, and how that information might indeed be weaponized against them. And that's why the HIPAA guidance that has come out from HHS, I think, around what can and cannot be shared, or what needs to happen before someone is allowed to go to the cops, is both promising, but also not enough.
Sapna or Eva? We can move on to some of the questions in the, oh, did you?
No, go ahead.
Okay, sorry, we can move on to some of the questions in the chat then. One of them from Stephen Jamar asks about the impact of AI with respect to privacy invasion relating to abortion. Eva, I'm not sure if you want to answer that. It strikes me that, I wouldn't talk about that as having, it certainly boosts the law enforcement toolkit in chasing down, everything, and it could be applied to process, more data and do so more aggressively. But I'm not sure the degree where there's a specific impact.
I think that there's one thing worth highlighting when it comes to any discussion of artificial intelligence, which is garbage in, garbage out. Artificial intelligence systems are frequently trained on data that it has racial biases. And so it is more likely to be wrong when facing data that belongs to people that are historically vulnerable and that have historically been more targeted by prosecutions over their pregnancy outcomes. So if I had to look into the future and give a guess about how AI is going to impact this situation, I think that I can safely say that that the use of AI to predict who is pregnant and who is seeking an abortion and who has had a negative pregnancy outcome will disproportionately affect Black women, Indigenous women, women of color, people who have already been targets of these kinds of prosecutions, and also that it will disproportionately affect people who are already living in poverty. Mind you, this is a safe prediction to make for anything relating to artificial intelligence. But there it is.
Yeah, that's a great point regarding AI's potential to further drive criminalization of historically and target of communities that are already targeted, and that it will sort of reinforce that influence in the same way that it has for other areas of law enforcement. There's a question from Troy Copes on a potential prosecution for providing services in support of, or assistance in support of, people who want to cover their digital tracks. I'm not sure the degree to which what an organization like EFF does, which is sort of general purpose privacy protection. I mean, the same things that are going to protect you. Good practice in this area is good practice in other areas too, I would imagine. So I'm not sure the degree to which it would be specifically applied there, but I'm not sure if any of the panelists want to take a shot at that.
I could talk really quickly about something that EFF has done. So I have been part of the team that has put together EFF's privacy and security advice, which you can get to at surveillance self-defense, ssd.eff.org. And we have included a number of guides for people who are seeking abortions, and also for people who are doing abortion support. And I think that is the strongest argument that EFF can possibly make to say that we think giving this sort of advice is not just legal, but important and necessary.
So oh, sorry, Kendra.
I guess I want to maybe offer one more point just to piggyback off of Eva. Like, yeah, you can potentially get prosecuted for lots of stuff, right? Like, there's a lot of law out there, and oftentimes whether you get you could potentially be prosecuted as like what the prosecutor ate for breakfast, right? So I think that we need to. I both very much understand this sort of. I think the desire to kind of like be like, okay, like what are we, how far down the chain can we go? What are the worries? And I think people are coming from a real place of trying to identify threats. But I also think that, partially, I think in some ways, what I think is realistically, there existing in the world creates some amount of legal risk. Unfortunately, you're not going to get out of it. And, both potentially seeking an abortion in a place where it's illegal or offering support for folks who are seeking abortions does create legal risk. That doesn't mean it's not the right thing to do. And it doesn't mean that people shouldn't do it, right? And I think that we often talk about legal risk, and especially criminal legal risk, as if the goal is to basically get it to zero or to avoid it entirely. And I think for me, I just want to remind folks that there have been folks who have taken incredible risks in order to do the right thing throughout the history, like both the history in the United States and, in everywhere else too. And that, part of our jobs as folks who are working in the space in tech policy and also just people who are humans, is to not sort of center our own selves and our own risk concerns when what we're talking about is like folks' lives and folks' ability to control their own choices and their own bodies. And just be like, okay, like even if I do run some small risk for giving someone advice, and again, I agree with Eva that like, again, this is not a thing that's keeping me up at night. That risk is so much smaller than the harm that would result in not doing it. And I think that's where I fundamentally come back to on this stuff in terms of just being very, very careful about how we prioritize talking about risk, very small amounts of risk for people down the chain, when the harm that we're talking about in people not being able to access services and access abortion is really like incredible.
Can I build on that really quickly?
Please.
So I just want to emphasize what Kendra just said, going back to what you were talking about earlier, Michael, about intersectionality. Let's also think about who is being most impacted by these regulations. Right now, there's 70% of the people that are getting abortions in this country are at or below the poverty line. If you break that down even further, it's mostly Black and brown communities. And then if we add to that the tech implications of what's going on, we know that Black and brown communities are the most surveilled in this country. Undocumented folks live in constant fear of surveillance. So when we look at that, when we look at people of color, look at low income folks living in rural neighborhoods where oftentimes everyone around them tends to be more conservative, is going to be oftentimes believe in they're of the forced birth camp, and they have limited access to healthcare in general, we really kind of see just how this law, what happened with Dobbs, is making the most vulnerable people in our country even more vulnerable. And it's showing us the privilege that others have. And so that fear that we may have is definitely something that exists, and it's going to continue to exist. The model legislation that's being put out would around aiding and abetting and criminalizing such behavior is scary because it's very, very wide, but that is still limited in terms of when you see that there's actual lives at stake. And these are lives for people that have been facing reproductive oppression for decades. And now it's technology as a form of that reproductive oppression, which just heightens those fears. So I think we need to think about that intersectionality with this because it just exacerbates the problem just that much more.
May I add something?
Please.
Just really quick. The flip side of the way in which Black and brown communities are going to be and have already been impacted by policing is that the tech community, people who do have money, people who do have privilege and power, are obligated to use that power to protect the people who are being targeted right now. if we are the people who are taking less risk, if we are the people who are less likely to see the consequences of these laws, then we are the people who are morally obliged to take some risks, to put ourselves on the line in order to protect the people who are most likely to feel the impacts of this litigation. And that is why we need to be having these arguments inside of tech companies, inside of the people who are running, inside of the companies that are running the platforms, which are made up of people. Because if you are sitting in a room full of corporate lawyers are largely there to caution people to not do anything in order to reduce the risk to zero. And it is only it is the work of engineers and it is the work of executives and directors right now to say, no, we're going to take some risk. We are going to accept some risk because it is important to protect these vulnerable populations, because these are our users and this is our moral obligation. Because what we're seeing right now is actually a tremendous chilling effect across platforms where people are very eager to comply in advance in order to reduce the risk that they're taking. And when people comply in advance, suddenly you don't even need legislation, you just need fear.
I wonder if any of the speakers, any of our panel is interested in commenting on some of the back and forth that took place in the chat a little while earlier regarding cycle tracking apps. And, you know, the counter argument to advice to delete them would be that with closing space around reproductive rights, it is imperative for people to arm themselves with that information and to be able to track their periods, to track their ovulation more carefully. Is that a tension that any of you see, that any of you want to comment on?
I think that people should concentrate on using apps that have better privacy policies, that have better privacy protection, and also really turn their attention to steps that they can take that will have a more immediate impact on the kind of information that is used against people who have negative pregnancy outcomes. So again, deleting your period app is a thing that you can do. It's just not the most effective thing you can do, and it is not a thing that's going to affect whether or not you are prosecuted for your pregnancy outcome under the current circumstances.
Yeah, I've written about this as well. So I'll keep my thoughts on it relatively brief. I think the other thing I will say, and I think this actually relates to the kind of conversation we're having about how folks who are who are not necessarily used to running legal risk or thinking of themselves as targets of the criminal state respond to a moment in which they suddenly see themselves as potential targets of the criminal state. Because I think the reality is, and you know, I primarily draw on my experience working with sex workers for this, is that you can't actually get rid of every single, like you cannot live your life in such a way that you will leave zero traces of any criminal activity that you engage in if you're going to get an abortion, right? Like maybe somebody can, almost nobody can, right? I just don't believe that that's a realistic thing to shoot for. And in fact, like experts like Eva, very reasonable, are like, that's not what you should be shooting for. And so part of why we're talking about like prioritization and what you should do and like, you know, how to think about your period tracker is that all security advice in these circumstances is a matter of sort of just prioritizing based on the knowledge that we have and triaging to what extent what steps are going to be possible for you to take versus what steps are going to be harmful. And I think that's, you know, when you talk about sort of gathering information about your period in order to, you know, potentially know how far along you are if you have to seek an abortion, like that's super valuable, right? And so I think that I see a lot of the anti-period tracking stuff. And I think this actually gets to a question in chat about like, what's the deal with the criminal thing or like civil and criminal things. As a sort of response to a moment in which folks who are not necessarily might not nor usually expect themselves to be targets of criminal systems confront the power of the criminal law in the United States, right? And I think it's really important to identify that here because many of the things that we would think of as the tools that we use, that folks use outside the context of criminalization don't necessarily work in criminalization, right? You know, it is great. Like I will absolutely want, you know, companies to ask for a warrant or a subpoena, before they give data. I want them to delete it so they don't have it. But if they didn't do that, I want them to require adequate legal process. Unfortunately, the reality is if abortion is criminalized in a particular state, they're going to have adequate legal process from that state to ask for information that is in somebody's private account, right? And I think in some ways there is, I feel like there has been this moment in which the reality of what it means to deal with the consequences of criminalization and the power of police to get information about our lives that might be used against us is in some ways the sort of thing that we're confronting when we talk about Dobbs, especially in the tech policy space. And so for me, I think it comes down to this sort of, to thinking very, very much about what are the pros and cons of individual choices for you, right? If your period tracker is useful, as Eva said, switch to one that is more privacy protecting. Folks mentioned Yuki in chat, which is the one that I think many folks have been suggesting. But I do think also just being really thoughtful about how, one of my amazing colleagues, Lorelei Lee, said, just remember it's not your fault. Right? The reality of criminalization is that sometimes, you may get caught doing something that is criminalized and it's not, you could have taken some steps and you might have not taken them. And also maybe you took steps, you did everything you could and you still, got caught, right? Like it is not your fault. And I think I come back to that because I do think that, we're often used to placing assuming that folks have some sort of individual control over these outcomes. And I both think I want folks to take steps to protect themselves, but I also want to remind folks that like when you are facing the power of the criminal legal system in the United States, like there's a lot that's just not on the table in terms of you being able to protect yourself.
Yeah, I was glad that you brought up the privacy, the civil and privacy question that Catherine Sweetser, one of our UCLA colleagues, brought up. I don't know, Sapna, if you want to address that at all, given your own prior background on the ACLU, or you can feel free to pass if you don't want to.
Yeah, sadly, that's not an area that I feel like I'm an expert on. I don't know if Eva or Kendra, if you have more to add, but I wouldn't be comfortable speaking to it just yet. But I'll definitely do some digging. Hopefully in the future, I'll know more.
So, speaking of the kind of, oh, sorry, Kendra, did I cut you off?
I mean, I can offer a little bit of a take, which is to say, could hack data be used in civil litigation? Like, it depends is the straight up answer, like classic law professor, right? Which is to say that I think there's a lot of questions that you might have to answer about sort of how you would authenticate that kind of data. But I think it's not like facially implausible to me, and then I think that when you think about like subpoenas issued in the context of civil litigation, right? You would want to think about both the Stored Communications Act, but also how individual companies have sort of built practices around resisting requests or not. Because the reality is that even if something could be protected by the Stored Communications Act, if a company is willing to turn it over without appropriate legal process, your ability to challenge that effectively may be quite limited. And so it's worth thinking about both like what legally can you do or can't you do, and then also practically, like if someone has access to that information, how does that change the game, right? In terms of either civil litigation or criminal. So for example, one of my colleagues, Megan Graham, has emphasized that like it's not just about whether something can get admitted against you at trial, but whether information can also be used to find other places to look for information on you, or to try to force you to agree, a defendant to agree to a plea deal, right? And so just thinking about, when we think about information, I think, it can be easy to reach for some of these legal solutions. And there are like good legal defenses and, in some cases, but it's also important to remember that there are other ways in which it gets used.
I wanted to put the question from Jelaine Lovejoy to our panel on sort of building on what was mentioned earlier about this idea of garbage in, garbage out, and whether there's any potential to sort of widespread efforts to pollute the data stream around tracking for these kinds of issues. Like if guys all over the country all downloaded period tracking apps and just turned it into a complete garbage data stream. I know that maybe that's a silly question, but I think it's a funny idea.
Please don't do this.
Okay.
Please don't do this. It's not going to work. It's one of those sort of feel-good ideas that feels very effective. Like, I'm throwing trash into the system, but actually it will not affect anything. And right now we are not seeing dragnets. We really need to focus on the immediate threats to people right now. We should be thinking about what dragnets might look like and how to change systems so that when the dragnets come, they cannot function, or it is harder to get the data. But throwing trash data into the system is really not terribly helpful, because it both fails to address the immediate threat and also fails to distract from users that actually need protection.
There's two specific questions at the bottom related to the Earn It Act and the Lawful Access to Encrypted Data Act. Does anyone want to take a shot at those, at either of those? I'm sure our panel has thoughts.
Who wants to channel Rihanna Pfeffercorn in this moment?
I don't know if I can do it justice. I don't have an 18-page chart that which I will drop a link to the thing that Eva and I are referencing. So okay, so right, for folks who are unfamiliar, Earn It and the Lawful Access to Encrypted Data are both, they're bills that are sort of basically either incentivize or require companies to basically stop doing the kinds of things that Eva has said you should go use those tools in order to keep yourself safe. And I think here's the thing, right? Like, if you didn't understand why that mattered before, this is a great explanation of why access to encrypted communications and to be able to use disappearing messages on Signal or use Tor matters, because it turns out that we may not always like the consequences of the state having access to our information. And so I think that in some ways, basically, it just re-ups the importance of opposing those kinds of bills. And specifically, as Rihanna has, I think, very helpfully done in a lot of her work, pointing out that to the extent that Democrats previously had been supportive of attacks on both, and this is me channeling a little bit of Evan Greer as well, Section 230, but also encryption, because they viewed them as sort of a way to either get at tech companies or because they thought there were important interests, which is fair, that were being harmed by the existing technologies. Encryption is really important for people to be able to protect themselves, and I think this conversation just shows why.
So we had one question from someone that they sent it just to me as opposed to the general chat, so I won't say their name. But I think it's a good one to try and close on, which is what current law students can do to help. And maybe we'll get a response back from each of the panelists before we wrap. Starting with Sapna, maybe?
Sure, thank you. I think, for current law students, one is continuing to understand and recognize the intersectionality of these issues. If previously you were interested in privacy, recognizing that it's more than just privacy related to big tech companies, but it really impacts every facet of our lives, including reproductive justice is a big component of it. I think that's really important. And then one of the big things that I just keep seeing is putting pressure on companies to do better, to rise to the moment. Right now, in my mind, their action or inaction speaks volumes. If they don't act to protect the information of people that are visiting their websites, using their apps, then they're supporting the prosecution of folks that are seeking an abortion care or of pregnant people. If they act, then they're really making it known that we recognize the impact, the harmful impact of our data. We're minimizing that use because we want to make sure that you feel comfortable using our websites, and we are finally recognizing the need for your privacy. I think putting that pressure on companies, putting that pressure on our legislators by using our voice as law students, as lawyers, is really, really impactful, because this is the future generation of leaders, future generation of lawyers that are going to be practicing in the field. And I think pressure works. I think we see that with what President Biden has finally done. It's a small step, but it's a step that I think only came because people raise their voices. And if law students are able to do that, signing on to letters, being a part of groups, taking initiative to really push the envelope and recognize that this patchwork system of laws protecting reproductive health care, limiting reproductive health care, protecting privacy, breaking it down to so many different ways is not working. We need to do more. We need comprehensive legislation, and we need companies to do better. And so I think pushing the envelope and raising our voices in that way can be really helpful. And thankfully, a lot of schools are creating opportunities for that. UCLA has lots, so get in touch with Michael and I for those. But that plug aside, I think there's a lot of power in that collective voice, and law students are in a really unique place to use it.
Eva?
Oh, I can't beat Sapna. I believe she has dropped the mic on this.
Kendra?
Oh no. One more quick thought to follow up on agreeing very much with Sapna's very concrete advice. So I'm going to do the opposite and go like very much more like theoretical, which is to, I think that, for me, and I've talked about this a bit. I think the sort of post-Dobbs era represents a really incredible opportunity for those of us who have more privilege, and especially those folks who work in law, to re-examine our assumptions about what criminalization means, right? Because I do think that the reality is that it has always been true that like what is criminal is not necessarily immoral or bad or wrong, and what is not criminal is not necessarily always good. But I think that law schools don't, this is not, in some ways, it's very easy to go through law school and sort of have that belief, supported or just at least not challenged, right? And so I think to the extent that part of what we're having this conversation is about the ways in which criminalization is just going to change this landscape entirely for a group of folks, and sort of in some ways put folks in a place that is very similar to the experiences that many like folks who are on accessing public services, women of color primarily, were in with regards to kind of trying to find abortions. I think that it's really valuable to just remember that, like, in the words of Mariam Kaba, like, let this radicalize you rather than lead you to despair, to say that, this is real, like this is a real thing that happened. And if it's true about this form of criminalization, what other forms of criminalization are also wrong, are also harming people, are also not a good proxy for what is okay and what is not okay, or what is good or what is bad. And so, in addition to Sapna's incredible, very specific advice, my sort of more general advice is to really allow this to help you reconsider your assumptions about what's true, to the extent that you had them, about how our criminal legal system interacts with the lives of everyday folks.
I think that's a fantastic note to end on regarding the potential for this as a moment of mobilization. I want to offer my thanks to our panelists. It's certainly a very challenging area of discussion, but it's also an incredibly important area of engagement. So hopefully this has provided some useful information for folks here. I'm sure this conversation is going to continue over the coming months and years. Thanks to all of you, and thanks for attending.